All right. Okay. Welcome everyone to our February meeting. Glad you guys were able to join us, and thank you for doing that extra step with the registration. It was so we know who's on here, so we can be better and faster and more efficient with our grant reporting. It really helps us a lot, and I'm glad that it wasn't that hard to get on there with the new step. Today, we've invited Carmen Marquez, and I know you saw in the emails that she works for the Victim Advocacy. She'll tell us a little bit about where she works there in Fort Bragg and what services they provide for military members and their families. One of our community of practice members, Devin Trago, works closely with her and thought it would be a good complement to some of the presentation that we saw in December. And so for Carmen and for the rest of us, if you guys want to put in what city and state you're in, and if you are close to any military base. I think I said this last time, but I'm in El Paso, Texas for this meeting, and the big military base here is Fort Bliss. We do see a lot of military families here in our state courts. And while you do that, I wanted to see what you all thought of our last speaker. What things did you find interesting, or did you not know about military families and divorce? And was there something maybe unsettling or uncomfortable about what was covered? I can start off with me that I felt that he kind of, for me, I felt a little bit nervous when he talked about we should really think about the consequences with reporting domestic violence and the consequences that would happen with the military members. I think that was a valid point, but I also felt like we were missing the other side and what support they have. And that's why I really thank Devin for connecting us to Carmen to have us join us today. And so we could hear what services they do have for survivors and for victims and for their families. Are there any other thoughts of our speaker last month?
Rocio, it seems to me we're a little low on the number of folks we usually have. I did notice when I opened up your meeting request that it had a link to a Teams meeting. And I wonder if some folks may be in the Teams meeting. You may just want to check.
Okay. All right.
I can open it up too if it's easier and just tell, and then I can put the Zoom link in that you sent me if that's
okay, because I didn't see where the Teams link went.
I'll just check. I might be wrong, but I almost clicked on it, so I thought I'd just mention it. I'll go over and check.
Okay, thank you. And then Kat. So Susan shares, and I'll share what's on the chat, Carmen, so you can see. So we have, Devin and Fort Bragg, and Fayetteville. Wendy's in Rockford, Illinois, and DeKalb, and the closest military base is the Great Lakes Center Naval Base in Chicago. Susan in Philadelphia. They don't see very many military families these days. Cynthia is in New York City, and the closest base is Fort Garrison, Hamilton in Brooklyn. Bobby's in Westchester County, New York. Now to the West Coast, Bellingham, Washington, and she sees the Navy. So that's what we're seeing, and hopefully maybe more will join in as the hour goes, and Devin, give them the heads up on the teams. I'll go through my regular slides that we usually do, but a thank you to the Office of Violence Against Women for this time, for this funding, the opinions, findings, recommendations that we talk about during this time is of the Office of Violence Against Women and not of our own. I mean, they are our own. It's not the Office of Violence Against Women. And then, the usual crew, Leslie and Veronica and myself. Leslie is in another meeting and Veronica had court. So in the slides, we'll all be willing to share the slides, and then Carmen, we can share your slides too, also with everyone at the end. Are you okay with that? Yeah. Okay. And then I'm going to have a new speaker for us in March, and I will go ahead and announce the date. Look for it. I'm thinking around the 20th and on, where we usually have our meeting close to the end of the month on a Tuesday. But depending on their availability. Okay. So I'm going to go ahead and share your slides. And we'll go ahead and get started. If you can just start with, let me see. Do we have them? Share screen.
So
There
I
we
think
go.
as you're pulling them up, I just want to say I'm a victim advocate with the Fort Bragg Army Community Services. And I have worked for Fort Bragg for now 5.5 years, a year and a half doing victim advocacy, and then the other years I've spent doing child advocacy and training for parents who either were in the process of a assessment through family advocacy, or just parents who volunteered for the parenting training. Having said that, prior to that, I did foster care case management in the foster care system here in North Carolina. And I also worked for the guardian ad litem program in Cumberland County as a guardian ad litem supervisor. So I've definitely worked alongside of many attorneys, but I'm not an attorney and I profess to be an expert in terms of, if you have questions, I definitely can figure out to get the information. But so having said that, I think, we can definitely move to the next slide. I definitely want to provide you with the information on what is domestic violence or how it's defined. And it seems like a lot of you come from or nearby different installations, not necessarily Army. Some of what I'm going to be discussing is applicable to different branches, but everything really is really is focused on Army. But and I will reference the items that are more so general. And even though my focus is Army, each branch has their own regulations on the specifics that I'm going to be discussing. Okay. So also, as I'm talking, feel free to ask questions and post things on the chat if I can. I think I see that in the bottom every so often. But if you have a question or a comment that you want to add, please just join in. I have no problem with that at all. Okay. So we can definitely have a discussion. So first off, want to talk about the definition. So definitely want to talk about the definition, want to talk about our reporting options, because a lot of people are not familiar with the fact that we have different reporting options. Do want to talk about our role as victim advocates in both types of reports, kind of give an overview of an incident determination process and what that means. And, definitely, whenever families need to request for a military protection order and what we do, and then the process of a civilian protection order. Now, some installations treat those processes very differently. We do a lot of partnering with our local communities to make sure that that CPO process is a lot smoother for our clients. So I would say, just know that what I referenced to in Fort Bragg, and Devin can speak to, is that you may not find the same type of process in other installations. So we'll talk about kind of a little bit about jurisdiction in terms of military and civilian. And then lastly, just talk about some resources and things that we've encountered with populations in terms of non-citizen partners. So in other words, not necessarily the service members, but the family members who may be experiencing domestic violence, and they may not be native born, and what that kind of looks like in terms of challenges and what we are able to do. Okay. So I want to start out with the definition of domestic violence. And although this again says Army Regulation 608-18, the United States Code, or the Uniform Code of Military Justice, is across all, branches. So in and of itself, it is that any attempts or threats to use or force any violence against a person, and even when there is a military protection order, like if they violate it, that's still an act of domestic violence. A lot of the, in terms of our definition for what we use here, is really connected to the what we call a incident determination tree. So we have certain definitions for emotional abuse, physical abuse, and of course, sexual abuse in terms of what it meets for the incident determination criteria. And I'll go that into more detail. But for this, what it really says is that if it's an act of domestic violence is what it is as far as state law and military law in terms of anything that's attempting to threat or forces or physical, emotional, physical, and sexual. So biggest thing in regards to our definition of domestic violence is that in the past year, who is eligible for our services for us is really anybody who is currently, if they are active duty military, or if they are spouse, like they're married to an active duty service member. If they say that they were dating a service member, and normally back in 2019, there used to be a requirement that said that they needed to share the same home for 30 days. For our purposes, not for the purposes of like domestic violence or investigations, but for our purposes as victim advocates, our definition has expanded to being that basically if you say that you dated someone and you're connected to that person in some kind of romantic capacity, that then you would be eligible for our services, provided that you are an ID card holder. So for our services, that victim would have to have an ID card. And a lot of that has to do with the fact that you need to be able to access the resources that we have in the installation. So our next slide really talks about the main definition, and this is the Department of Defense instruction for intimate partner. So that's across all branches, and that's kind of the definition in terms of who is eligible for victim advocacy services across all branches. And that's basically what I discussed earlier, kind of in a nutshell, just using the legal terminology. But as I said, anybody who is in any romantic capacity and they say, hey, that my boyfriend or whoever, went on a date and he belittled me or, he hit me, that would be a report that we would accept. Now, with individuals who are intimate partners and they are not ID card holders, what we do is we still take the report, but we refer them to the local resources. So we wouldn't maintain that as a victim advocacy case per se. So a victim advocate would not be assigned. They would just refer them to the local services. Any questions about that as far as the eligibility for our victim advocacy services? Okay. So on the next slide, it's kind of different. A lot of people, when coming to the military, working with individuals who are military or military affiliated, who have made a report, or there's a report that was made, what normally happens is that either the report is made to us, and us, I mean the family advocacy program, we're the prevention side of the family advocacy program. And so that's where you find the victim advocates. Normally, we are the hub for reports. Anyone that is reporting any domestic violence, any child abuse would normally be directed to make a report to us. We victim advocates are required to have, or the program is required to have, a 24/7 on-call availability. So at any point, anytime, even on the holidays, somebody needs to make a report, that they can make it through our hotline. and that would be the Victim Advocacy Program. And then there is the Family Advocacy Program for clinical, and that program is more of a treatment. So when a report is made, either through the Victim Advocacy Program, what we do is we send it over to the Family Advocacy Clinical. And so what they do with it is that they do more of an assessment. So our goal is not investigative per se. Our goal is treatment and support and resources. So they talk to victim and alleged offender, and they assess, what happened and credibility of the individuals, to then gather the information and send it into the Incident Determination Committee, which we'll talk about here in a minute. But so oftentimes you'll hear victims speak about family advocacy. And the thing about it is that in some installations, family advocacy is together, and in other installations, family advocacy is separate. For Fort Bragg, family advocacy is separate in that there is the Victim Advocacy Program, and then there is that clinical team. So what you'll find is the victim advocate is normally the ones that will either go to court with the victim, will either look for resources for them, especially looking at resources in the installation or military services. They also are the ones that will ensure that, for example, any financial support that may be needed, that those commands, as well as that service member is, following through with those Army regulations, and is the one that will more than likely connect them to all of the other parties. If there's a criminal investigation within the installation or a special victims counsel, that victim advocate is kind of the hub for all of those resources and connections. So it's critical that when you have clients that are in the military, that they get connected with the victim advocate, because that victim advocate is really their main, connection to everything else that is going on in the installation. And of course, like I said, the social worker, in terms of treatment, they're just looking at assessing the situation to then move it over to the Incident Determination Committee, which I'll talk about that in a minute. So reporting options, why are they important? They're critical. And when we talk to victims, one of the things that we focus on saying is, first, I don't know who you are. And because if I don't know who you are, I really don't have to report, but I want you to tell me what's going on, right? And then once you tell me what's going on, we can definitely talk about, can I offer you a restricted report, or do I have to go unrestricted? And then you can make an informed decision. But our reporting options are, we offer restricted and unrestricted. And the reason that we offer two is because with a restricted report, you may have victims that are not ready to go forward. They're not ready for a criminal investigation. They're not ready to leave that partner. And so the restricted report allows for them to have access to a victim advocate who can help them safety plan, allows them to have access to counseling within the installation, allows them to get any medical care if they've been victims of sexual assault, that they would be able to obtain those medical safety kits, and of course not being used. That's a whole different other thing, but it allows them to get all those resources that they may need without notifying command and without the service member being aware, but being able to have all those resources. And a lot of the reason that people choose to do restricted is because they're at this crucial moment when they're not yet ready to move forward, but they're planning, right? And they need a little more support in terms of being able to do that safely. And so we do a lot of safety planning with that. An unrestricted report, on the other hand, are reports where we unfortunately are not able to keep the situation restricted. And oftentimes those are reports where the victim might be like, I'm ready to move forward. I want to be able to move safely. And I would like, for the military protection order to be put in place. I want to move with my family, like different reasons, but mainly, there are times where individuals can choose to have an unrestricted report or a restricted report. And there are times where we unfortunately cannot offer that choice. And that is if the victim has filed for a civilian protection order, Or if the local authorities is already involved, and that includes the military police. If they're already involved, we cannot make that report restricted. And the other part is that if, of course, if there's criminal, even in the civilian sector, if there's criminal charges pending there, we can't keep that restricted. Other things to keep in mind is, child abuse, because as you know, there always is there's a connection when there's children, that there's a potential that children were involved or that children witnessed the incident. So if there are children involved, we can't keep that part restricted. We're mandated reporters, and so we have to report that. Other things that we can't keep restricted is like threats to harm yourself, or that we fear that the situation is so lethal that if you leave this office today, that you could be in the news because something happened to you. So we do a lethality assessment when we meet with clients to look at how lethal is this situation and can we offer you a restricted report. Any questions about restricted reporting? So when it comes to, victims, especially when I think of victims who are in the process of immigration with their spouse, a lot of what I get is that, and I do find it to be very crucial that those reporting options are offered, because it takes a lot of planning for them to step forward and ask for services. One, because a lot of them have not been aware or not aware of the services. Even victims who have lived in the installation for years or native to the United States still find it very surprising that this program exists, and they may not come forward or may hear it from word of mouth. But restricted report, again, it's important in that it helps those individuals be able to make that decision before moving forward to involving all these parties. So the Incident Determination Committee. So we talked about Family Advocacy Clinical doing their assessment. And so when they do their assessment, what they do is they gather all the information that they receive, right? And then they, again, assess credibility and those things. And then they move it forward to a committee that is represented by the service member's command or a representative of that command, a committee that is represented by someone in the garrison, and it's someone from the Family Advocacy Clinical team. So it's a supervisor. So it's more or less like the heads of the departments. And all of those individuals, or those 4 individuals, including, well, it also includes somebody from the CID, so which is the Criminal Investigations Department, and someone from the medical team. And so those individuals are all voting members of this Incident Determination Committee. And so the purpose of this Incident Determination Committee is to determine whether what the incident that was brought to our attention meets the criteria for domestic violence under, emotional, sexual, and physical. And if it meets the criteria, what happens is that individual who is found to be the offender will be put in the Family Advocacy Program Central Registry. And so what that registry is, if you guys are familiar with the registry for CPS, it's similar, but not in that there shouldn't be any repercussions to a service member in terms of their job. Now, if the service member has committed numerous incidents, we're talking about multiple, or very egregious incidents, then, it's not that this committee makes any decisions about their job, but of course, all this information is provided to the commander, and the commander sometimes will make decisions about beginning to either separate the service member or may look into a more of a criminal aspect of that, depending on, again, the severity of the incident and whether this service member has had multiple incidents, or if the service member has had multiple incidents and then their behavior at their at their post or what they're doing. So in order for somebody to be removed for the military or have negative repercussions for an incident of domestic violence, it would normally take very severe and egregious and multiple incidents for that to happen. The purpose of the of FAP per se, or the purpose of reporting, is one, to provide, or essentially is to provide services for the family so that incidents of domestic violence don't happen again. We don't ever want to steer anyone from reporting, because the purpose of this program is to assist, and it's to prevent, and it's to make sure that we don't have, we're not in the news, basically. And so it is there to support those families through that process. So every incident and that includes domestic violence and child abuse reports are sent over to the Incident Determination Committee. And of course, once that determination has taken place, then a letter is sent to the command, who then provides that to the service member. There are times when I have found that victims of domestic violence who are spouse victims, they have used the incident determination letter, have requested a copy of the results from their family advocacy social worker to take that for immigration. And as far as serving for the purposes of, we are separated and this is why kind of thing. And so, yeah. I think the thing with victims of domestic violence who are in the process of immigration, if this committee doesn't find that the incident that they've reported meets the criteria, then there is no letter for them to show that they are victims. So just something to think about in terms of that. Any questions about this?
Carmen, I don't have a question, but I had a little bit of a comment. Sometimes when the IDC does not come back with a finding that it meets the criteria, that is something that if you have at the same time a civilian protective order matter going on, you may need to prepare for the possibility, especially if you have counsel on the other side who's used to taking military defense cases for DV. Prepare and compare the process of the IDC, which is why it's really helpful to have someone like Carmen here who knows that process. Reach out to somebody about that process, because it is not an adversarial, it isn't appropriate to bring up, and they're likely to bring it up. Was there an investigation by family advocacy? What did the, what was the determination? They'll even try to bring that letter in, or some other, determination, and just make sure, because it doesn't meet the standard for what the other attorneys tend to try to make it, as though it is almost some kind of a not guilty finding. And so just kind of be prepared to compare your standards of evidence for the jurisdiction that you're in to what the IDC actually is, so that you can make an objection to that being characterized in the way that a defense attorney is likely to try to characterize it, whether that's in custody or divorce or a DV protective order.
And you're absolutely right. There are many reasons as to why there are findings and why there are not findings. There are times that victims are fearful of, or are not aware, or sometimes the clinical team may not have the phone number for the victim. And if you don't have that side of the story, you only have the other side of the story. And so they go with whatever information they may have available to them. So yeah, it is not a punitive, it is not a criminal process. It is more of a services and a process for that family. Mm-hmm. Okay, so protective orders. And of course, I'm not an expert in terms of the legalities, but I will say that one of the things in Fort Bragg, what we do is our garrison has a letter for our installation that basically tells commanders that when there is an incident of domestic violence, no matter what it is, when you get a call from family advocacy, whether it's the clinical team or the victim advocacy team, they are supposed to implement a military protection order minimally for the first 72 hours, what they call a cool-off period. And that is to give enough time for victim advocates to reach out to the victim, and for the family advocacy clinical team to also reach out to the victim and the offender, and to create a safety plan, and then assess, do we need to, request a further, protection and military protection order. But keep in mind that the military protection order is granted by the command. So the command can decide after the 72 hours, and that's here in Fort Bragg. Now, different installations may have different standards in terms of a request, when incidents of domestic violence, as far as what that looks like. But nonetheless, 608 I think 18 is across. It really talks about in terms of each installation having its own requirements or figuring out its own requirements for how they're going to deal with incidents of domestic violence. But for us here in Fort Bragg, we do, like I said, we have that installation policy letter that requires that. And having said that, this is a joint base. So not only do we cover Army, but we also do Air Force. So our Air Force service members also fall within our requirements of having commands put that minimum 72 hour no contact order. Oftentimes what we find is that if like the victim advocate finds that there may be like additional things that may require for the military protection order to be more continuous, or keep it until the incident determination committee is over, that commands will grant that. We'll keep it open. We'll keep that protection order in place until that incident determination committee. But some commands will just keep it 72 hour and then move on. And at that point, if the victim feels like, they don't feel protected, they feel like the initial, that's where we really work in helping them get that civilian protection order. But again, it's granted by command. It's at the discretion of them. It's not signed by any judge, any military judge. It's command driven and enforced. So it only applies to service members. So when we have a family member who may be the offender, the military can't do a military protection order against that individual. So oftentimes service members will have to go, in those situations, the service member will have to go to the civilian court to file for that. The other thing to keep in mind in victims of domestic violence who are not military is that, say the victim, the family lives off post. The military protection order does not have any, like, if the service member doesn't follow it, it's not like he's going to be held in contempt of court, not in the military jurisdiction. So it really does, the command starts to starts to gather that information to basically look at the possibility of separation if they continue to not follow through with those orders, because it is an order from that commander. So oftentimes if we find that a service member or the offender / service member may continue to not follow through with an MPO, we encourage family members, especially if you live off post, to do a civilian protection order. We encourage them all together. I feel like you still can do a military protection order and have a civilian protection order both in place. And I think that's probably the best practice. Oftentimes what I tell commanders, because you have some commands that will say, oh, there's already a civilian protection order, we don't need the military protection order. And I'll say, yes, we do. I think what you need to do just to cover yourself is make sure that you mirror that so that it says the same thing. And there's no question about, what's put there and what's not. In terms of impact, a civilian protection order does not automatically disqualify a service member, or it doesn't automatically put them on the separation process. Again, it's very command driven. If the command feels like this is a egregious situation, if the command sees that depending on the service member, and how they are in their unit, or is this numerous multiple times, then that command may decide to begin looking at separation in court martial. But it's not an automatic. We have had, or I've known of service members who had the civilian protection order and was approved, and they still have their jobs. And we have some that even had criminal charges at some point and even went through court martial and we're not separated. So it's not an automatic. Would it impact? I'm never going to say no, because it really is depending on that service member and depending on that command, whether it goes through that process. Anything you want to add, Devin?
I think that's a really good point and relates a little bit to some of the concerns that we may have had coming out of the last presentation about, the tendency for, I think, both military members talking to each other and also their attorneys to make it as though, the victim getting a civilian protective order is automatically going to lead to loss of income, loss of, health insurance through TRICARE because the person's going to be separated from military service. It really isn't true. And I find it very important to consistently push back on that. There are military members, there are police officers, there are, everywhere who have protective orders against them don't automatically lose their jobs. So I think it's really important to push back on that. So I appreciate you mentioning that, Carmen, and in some cases as well. And I know that this is not something that I think, in my experience, it's very fact dependent. So not necessarily something that Carmen or anybody can give you too much specific information on, but there are also some cases where the military has some resources that they may be able, for instance, to keep, even if the military member is separated, they may be able to keep health insurance, for the rest of the family for a certain period of time or something. So if that message has gotten to your client, either from the abusive party or also, there are a million military spouse like Facebook groups and things. And we have one attorney here who is a military spouse who is it's practically a part-time job for her trying to correct all of the misinformation on those groups. So if some information has come to your client where they're super nervous about proceeding to do something that will increase their safety because of those kind of rumors about separation and what that will mean, you can't make any promises because it's not in your control, but have them talk to somebody at Family Advocacy, talk them through yourself, what the benefits are and what the options are and what the protective factors are, because I see a lot of folks drop orders and drop criminal charges that really don't need to, out of fear of the impact of a potential separation from the military. A lot of our survivors feel a lot more comfortable with their abuser being in the military because there is a command. They can be restricted to base. They can be, sent to another country, and have that kind of separation that makes our clients feel safe. So I try to make sure that they know that it isn't, just as Carmen just said, it's not automatic. There's a lot in between absolutely nothing happening and a separation of a military member.
And having said that, just piggybacking from what you said, I think our next slide really talks about assistance for victims. And I'll go ahead and go to the last one, because transitional compensation is a big resource that is there to support victims who have had their service member separated because of domestic violence. So that's why having a victim advocate is critical, because through the process, the victim advocate, if they find that the situation that this victim is going through is a potential for meeting the eligibility for transitional compensation, that victim advocate will definitely let that victim know so that they keep that in mind, and that you don't have to be a U.S. citizen to have that transitional compensation eligibility. It is really based on that service member having been found to have been having abused of that victim and having been separated. I think the key thing is having been separated for those acts. And so there's sometimes where that they're separated, the act happened, but the paperwork associated with it doesn't have that. And that's something that our victim advocacy program kind of works through that. And there's some exceptions, but again, biggest thing is if the victim was a victim of domestic violence and they were charged, so one of the civilian charges, they were charged, and then the command made the decision to separate them because of that charge, that victim would be eligible for transitional compensation. And so what that means is that the victim would be eligible, as well as their children, provided that that victim doesn't remarry, that they would be eligible, the whole family would be eligible for the financial support. So all finances, and there's certain formulas, but it's based on the number of children. And so they would be eligible for that transitional compensation. Children, and it's based on the number of family members that are in the home. Then they also would be eligible to continue on their medical benefits with TRICARE. Up to 3 years of both financial and TRICARE benefits, as well as dental, as well as the access to the military installations, like, the PX, like the commissary, those kind of things. They would still have available for 3 years. The important thing, as I said, is keeping in mind that they stay connected with their victim advocate, because they're the ones that fill out the application, and then there's that waiting period. And in the process of separation, depending on whether they go through court martial or not, that if they have a special victims counsel that's working with them, that they can, if they're going through court martial, that they can request that payment that's normally given to the service member be deferred to the victim, so that while they're serving their time and the process of transitional compensation applications taking place, that there's not that cutoff of financial support. Now, we can't guarantee that there isn't going to be a cut up in between. So one of the things that the victim advocates really try to work with, it's what's plan A, what's plan B, to make sure that, you, in that transition, that you're covering yourself and you're taking care of that. Okay.
And Carmen, I have a question there, and maybe Devin will know it, but would a court order for child support hurt this transitional compensation? Or would they take it in? Could it interfere with that order or reduce it?
No, I mean, one, transitional compensation is for the victim. The victim doesn't have to share this with anybody. This eligibility for transitional compensation is not discussed with the offender or anyone except for that victim. So, and again, it's actually not tax deductible. So it's not tax deductible. It's not, you can't put it in your taxes. Like you don't have to, you don't have to report it. And so this victim doesn't have to, she doesn't have to, if you say, if I'm the victim, I don't have to tell anyone that I'm receiving this money for all intents and purposes. So yeah, it does. It could, it depends on who finds out, basically. And I don't know.
I would note that on something a little bit different, though, that I think we have seen, Carmen's office and our office have done some family law clinics with each other, and it was really helpful. It has been really helpful to kind of interact in that way, because we had kind of the military law section, then a civilian law section. One thing that you would want to direct someone to talk to family advocacy about is that there is, if the parties are married, and the military member will have a responsibility of support to their dependents, and so children, spouse, and that number theoretically could be higher than what you may get out of a child support, or especially if they're trying to make an agreement, just like a separation agreement, because the military member may know that number and may try to save money. So if there is no agreement on the civilian side, the military is going to use the formula that they have, which is fairly generous. But if you do have a civilian agreement, that is going to supersede anything that the military would do. So if you experience a military member who seems really, really focused on like working it out through a separation agreement or something, I would recommend checking in with family advocacy. They can let folks know what that amount would be, and then that your client could make a more informed choice, because there's also some benefits in that. Carmen, correct me if I'm wrong, but that money can just be directly sent from, like, it doesn't have to be the military member giving the money. It can be taken from their pay and sent directly to the survivor, right?
So yes and no. It does. It is up to the service member to ensure that it gets sent. And ideally, it would be that it would be taken directly from their pay and sent over to the victim. And so if that's not the case, then that's when the command gets involved. And then they do the whole process of counseling the service member for not providing that financial support. If it's still that doesn't happen, then, options for families is to go through Inspector General, and then Inspector General would do an assessment. And again, it'll just trickle down there. But yeah, unfortunately, commands cannot directly make those changes. Those are changes that have to be done through the service member themselves. But it just almost adds to the list of just UCMJ. You're not following these things, and that's
there is somebody else pressuring them beyond the victim. But so that can be helpful if you're going to make command angry, it might cause the person to give up those funds a little easier than if it's the civilian courts that they can ignore. But I think the main takeaway is, if you have someone who's military connected, who is considering filing for some kind of support, or more importantly, making a separation agreement or a separate agreement for child support, please have them check into whether that amount is significantly lower than what they could get through the UCMJ amounts that would be required otherwise.
Mm-hmm.
Yeah, and you're absolutely right. They're a lot more generous than what you would get in child support. So if you have a lot of people that what they decide to do is go through their in the midst of the separation, and it depends on which state, because here in North Carolina, you have to be separated for a year before you can file for divorce. So you have a lot of people who will wait and use that, BAH rate that, is required to, before they start making, plans for like, what is it that they're going to give for child support or request and that sort of thing. So absolutely, I would say do that. And, have the judge, advocate general, different installations have different, access in terms of what their JAG teams can do. For Fort Bragg, our JAG team, both in the Army side and in the Air Force, they have briefings every Thursday, which they talk about divorce and separation. And that's where, the legal aid and ourselves are partnering with them to provide a piece of what is it that we do, and, include our clinics in there. But I say that to say that different JAG offices will provide kind of legalities in terms of, what are the service members' requirements to provide for family members in separation and divorce, without having to get to the domestic violence aspect of that, if that's not something that victims want to get into. Special Criminal Investigations Department normally investigates crimes of domestic violence, but things that are more egregious. So we're talking about strangulation and sexual assault. It's normally where the Criminal Investigations Department will take. So if you have a situation of sexual assault or strangulation that has taken place in the civilian, not in the installation, but has taken place outside of the installation, the Criminal Investigations Department may still take that case and try to prosecute it on the military installation because of the severity of it. So just keep that in mind when you're looking at victims who may be, going through those situations, that may still be referred within the installation. Other things to keep in mind is that if the victim's not ready to go forward or press charges, a special victims counsel is actually an attorney in the military that is assigned to victims who are victims of sexual assault or strangulation or, you know, severe physical domestic violence, and that's incidents in the installation, or again, things that may go through the criminal investigations department. They can consult with the victims and can keep that information confidential, and what they do if once the victim decides to move forward and have the criminal investigations department assess it or move forward to the civilian, they can only do so much in the civilian sector, but a lot of what they do is actually in the military. So what they can do is they can accompany and prepare the victim to testify or provide their statement to the criminal investigations department so that they don't have to do that alone. So keep in mind that in situations like that, if you're working with somebody, you know, consider asking if they're already working with a special victims counsel, or if there's already an criminal investigation in the criminal investigations department, and for them to reach out to their victim advocate to get those things moving if that's something that they want to do. Other things to keep in mind as far as ACS, and I know I saw some questions, I just couldn't read them. They were going too fast. Rocio, I don't know if you are able to read them. We could definitely go over that. But as far as ACS, we're more prevention, and we work with victims. We do offer services like new parent support programs for like mothers of young children, even pregnant women up to when their babies turn, I think 36 months, and they're actually able to travel up to like 2 hours from the military installation. At least Fort Bragg does. So get with your local installations to see if those programs may be available to individuals within your community. But financial readiness is a program that we definitely recommend to our victims as they're moving out of the situation, to kind of assess where they are financially and kind of make goals and plans for where they want to be, as they're moving through this process. And employment readiness is another one of the biggest programs that we also share with victims, because of course, one of the biggest things is trying to be, independent financially is one of the hardest challenges for victims in trying to get out of that situation. And I've already talked about transitional compensation in terms of what that is, as far as support victims.
Yeah. One of the questions that one of our colleagues has for you is, does the military assist a victim with alternate housing on post? Yes, it's on BA, I think base, if that's where the family was the family was living on base, do they assist with alternate housing?
So the Army, the regulation for financial support states that if I get to it, but it states that if a family lives on post and the service member has to leave the home because of domestic violence or civilian protection order, that the service member does not have to provide them with any financial support per that regulation, because the BAH is what covers that housing. So that's where I find, it's critical to have a victim advocate and look for outside resources, because unfortunately, you have families whose like if you have an immigrant family, they may not be able to work. And so they don't have funds to be able to provide for food, which is they need to eat. So victim advocates may advocate to have the service member provide additional funds to support that, but that's not guaranteed. So we look at local community services, food pantries, those kind of things to assist the family with those basic needs. In terms of alternative housing, say the victim wants to move out of military housing, the Army regulation or the regulations normally, and again, that depends on the actual branch. So always contact that victim advocate from that branch to give you those details. But majority of them, what they state is that once that victim moves from on-post housing, that service member has 30 days to start making payments for that BAH rate. and then provide a differential, which may fall between like $200 or $500, depending on the service member's rank, to help assist with the move. It's not a lot. Which is why, we ask victims to start planning as far as saving. We look at other community services, but we don't necessarily have like a shelter. We don't have a shelter here in Fort Bragg. We have to partner with our local agencies and domestic violence shelters to be able to provide that. So we don't per se, have that housing here available. And I don't know, I think the only installation that I'm aware of that has a shelter is Hawaii.
Yeah, that's
Did that answer
interesting.
that question?
Yeah, we wanted to know if they would provide for them to move out there, and I think your
Here's-
answer is no, but that the service member is going to have to provide a portion of that BAH to cover some of that.
The other piece to keep in mind also is that in egregious situations where the family member has to flee, like they have to leave because of safety, the victim advocate can advocate for the command to provide or assist in a safety move. And so those safety moves are command granted. So the command has to approve it in order for us to be able to provide that safety move. And with the safety move for us, it's just that it just pays for the flight. It pays for the moving of their items, like if they were moving to a different installation. So it really just pays for moving expenses, but not for housing.
Okay.
And those safety moves are particularly helpful where, oftentimes folks have moved to a place that they have no connections. They've moved away from family. Those safety moves can be wonderful if you have someone who has a family member who can provide that housing, that safety, and that financial support while they're getting back on their feet. Those safety moves can be really helpful for that.
Yeah, that's right along where I was thinking that the support system is probably outside the base, and maybe it's a small community, and the pressure that they might feel there from others in the base might exacerbate a bad situation.
One of the biggest challenges that I find with is that the custody, if there are children involved, that can be very, very challenging because a victim can't just pick up and leave. And we have some that have picked up and tried to leave, but and we've also had where the service member will file for custody and unfortunately may have been granted. And so then you have the victim having to come back and bring the children, and it becomes a very more traumatic situation. So definitely wanted to touch on these three in terms of some things or challenges that we face. Spousal support. I've actually had different people from different installations give us a call, and that's because we have a Spanish speaking victim advocate. So I've had a lot of referrals from Puerto Rico really calling and saying, hey, I've been here for 6 months. We've been married and my husband hasn't provided me with any financial support. Right. And so, we're working through that in terms of assisting that family members will, contacting commands or reaching out to Inspector General to assist them in getting that. But a lot of what I see is especially the spouses, where the service member will say, well, if you say something, I'll lose my job kind of thing. And as we said, this can be very frightening to family members. So we ensure that when separation does take place because of an incident of domestic violence, that spousal support is put in place for that family member. In regards to immigration status, we don't have immigration attorneys that provide those services. Fort Bragg does have a program where they help foreign spouses, but it's very minimal in terms of what they do. They just help process the naturalization. They help them through the naturalization process, and that's about as far as it goes with immigration. Keeping in mind, I always, when I talk to victims, discuss our reporting options in terms of restricted and unrestricted to help them kind of plan through what they're going to do. Because you do find there's a lot of isolation in terms of the service member, not allowing this victim to meet other spouses or or seek any services. And you also find that sometimes they haven't even given them their ID card. So, they can't even go get medical care or not even aware that they can get medical care because, the service member has really isolated them from that. So definitely one of the things that we do is immediately try to bring the family member up to speed with the resources that they are available here through the military in terms of our JAG or our separation briefings. And we do, I have not had to refer to the immigration services with legal aid, but I know that, and I say that only because the few individuals who I've worked with have had ongoing attorneys or immigration attorneys. So definitely my biggest advice is always, to contact your immigration attorney if you're working with one in every step of the way in this thing. But definitely biggest thing also that you find is that service members or these victims have said that the service member has threatened with their immigration status, right? That they are not going to, they're not going to get their immigration papers if they go forward. And it is a huge fear because sometimes what you find being reported is emotional abuse, or the abuse that's been reported may not meet the criteria for the Incident Determination Committee. And these victims feel like they've gone forward with something, and then it doesn't do anything. And now they've lost, their footing. So important, in terms of working with spouse victims who are not citizens. But we try to connect them to community resources, and that's part of ensuring that they're aware as far as talking to their attorney and how these things may impact them. Whether it's shelter, whether it's looking for employment, if that's within their grasp. I know currently, we're working with a victim who's waiting for their lawful permanent residency card to come. And so, she was living on post, and service member was not providing anything but what was required of them. And so we did a lot of food pantries around the area and, community services in terms of making sure that she got what she needed for her and the children that were in the home. Is there anything else that you might want to add, Devin, in terms of your experience with this in military?
No, I think it's really useful information. And I think that just thinking of that family advocacy, your advocates as a real hub of information. And, even if someone may not feel completely ready, that in some cases they can be those restricted reports, and just to come and get information. Some of my clients who've had trouble too with the friendliness of an abuser's command, going more towards the abusive partner than the survivor. Carmen will get on phone with command, and she will politely but firmly tell them what's what. And we're very lucky. Fort Bragg's garrison commander is very, very supportive of family advocacy, but it does give those advocates the ability to interact in a way that particularly someone who has a language barrier, or who has other reasons to be afraid of contacting a military commander, there's also that benefit. So I think just focusing on if you have someone who has the availability of an advocate, to just really encourage them to do so. I've literally never had a bad experience with ours at Fort Bragg. They've always been helpful. So I really appreciate you coming, Carmen, and telling everybody about that.
No, thank you. I mean, we're victim centered, so we're never going to talk to the offender. Definitely not in our role, and make that very, very clear. Our role is really to work with the victims in advocacy and referral and support. There are individuals who may come to just talk about their situation. I may never know who they are. And then I get a call like 3 weeks later, and they're like, I'm ready to move forward with an unrestricted report. And then I have some that, again, don't know who they are, may call 3 weeks and is like, thank you. It was very helpful, and still don't know who they are. But so we're really open to, basically, I mean, the goal of it is providing you with information so that you can make an informed decision on what you're moving forward to and what you're going to do. So that's, yeah. Thank you for the time, guys.
Yeah, Carmen, thank you. That was a lot of information, and I'm glad that these services exist. I hope that the outreach is there so that the services can become reality to the families and to victims and survivors. And I just wanted to thank you for completing us, going full circle with hearing with all the options that the military provides. And yeah, thank you, Devin, for connecting us with Carmen, and everybody for your time. If any questions come up, it's clear to me that Carmen and Devin will be able to answer or point us in the right direction. So now we know in our intake forms, ask that question: are you a member of the military, or is the spouse or abuser? Because there are this wealth of resources that are available, and it's good to know that they're there. So everybody, thank you for your time today, and I look forward to being in touch with you in March. All right.
Thank you. Bye.
Thank you.
Thank you.